I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about.
Today's case features one of the most baffling courtroom appearances you'll ever see. It's hard to imagine that in 2025, people still cling to these so-called sovereign citizen beliefs. But here we are. This defendant walked into court absolutely convinced he could outsmart the system, despite the fact that he can barely read, let alone navigate complex legal codes. His central claim? He insists the trial is unfair because, in his words, the prosecutor had 7 years of legal education, while he only had 1 hour to study the law. Yes, you heard that correctly, 1 single hour. It's like entering a championship marathon with no training and then complaining that the Olympic runners had too much of a head start. The comparison is almost laughable, but it shows just how detached from reality some of these arguments really are. What unfolds in this hearing is both frustrating and fascinating. On one hand, you can't help but shake your head at the level of misunderstanding on display. On the other, it's strangely entertaining to watch the court handle these bizarre claims with patience and firmness. The judge doesn't lose composure, the prosecutor stays focused, and the legal process moves forward despite the circus ACTSO as we go through this clip. Pay close attention to how the court dismantles his reasoning step by step. It's a real-time lesson in why preparation, education, and respect for the law matter so much. Let's dive in and see how quickly this man's misguided confidence collapses under the weight of reality.
Well, the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
It's honestly unbelievable. This man struggles to read basic text, yet he's standing in court confidently trying to present his own motions as if he's a seasoned attorney. Watching him stumble through his words, you can't help but wonder, what grade level would you put his reading at? Personally, I'd say middle school at best, and even that might be generous. But the most astonishing part isn't just the reading, it's his complaint. He's actually arguing that he hasn't had enough time to study the law. Think about that for a second. Does he really expect the judge to hit pause on the entire case for the next several years while he goes off to earn a law degree? The sense of entitlement here is off the charts. Back in the day, if you didn't understand something, you found someone qualified who did. You didn't throw a fit and demand that the entire legal system bend to your personal timeline. And the truth is, this man has already been given choices. He could hire his own attorney, accept help from a public defender, or proceed on his own if he truly knew the law. But it's painfully clear that he doesn't. So what's the next step here? Is he going to request a delay until he's sworn into the Supreme Court himself? At this rate, nothing would be surprising. Let's get back into the hearing and see how long this house of cards can stand before collapsing under reality.
All right, go right ahead.
For every waste of time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution, if need to. It's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on, and I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
at this point, you almost expect the judge to lean forward, give him a polite smile and say, "Nice try, but motion denied." Because let's be honest, that's exactly the direction this circus is heading. The way he read his motion, you'd think he was delivering a historic speech instead of wasting the court's time with baseless arguments. Now, I have a sneaking suspicion the judge only allowed him to read the entire thing for one reason: entertainment. Sometimes it's easier to just let someone dig their own hole than to cut them off right away. And truthfully, it gave everyone in the courtroom a chance to see just how weak his position really was. That here's the reality. Judges don't have to indulge this kind of nonsense. They can dismiss frivolous filings on the spot, And in some cases, they can even hand out penalties to discourage people from clogging up the system. Rule 11 of the Federal Rules of Civil Procedure exists for exactly this type of situation, to prevent individuals from filing motions that have no legal basis whatsoever. But of course, this defendant seems to believe that if he talks long enough, he'll somehow awaken the court to his so-called sovereign wisdom and walk away free. Spoiler alert, that's pure fantasy. The law doesn't work that way, and the only thing he's achieving is testing the judge's patience one sentence at a time.